Imagine this. It is 11:30 p.m. on a Tuesday. You are driving home from a double shift, exhausted but completely sober. You see the flashing red and blue lights in your rearview mirror. Your heart rate immediately spikes to 120 beats per minute. You pull over safely to the shoulder, turn off your engine, and place your hands on the wheel. This is the moment where most Americans make a life-altering mistake. You have watched enough crime dramas to think you know the script. You think, I haven't done anything wrong, so I'll just explain myself. Or you think, I have the right to remain silent, so I will just lock my jaw and say absolutely nothing. Both of these instincts are wrong. In fact, due to a shifting legal landscape and recent Supreme Court rulings, staying completely mute can actually be used against you in a court of law. My name is Sarah, and I am a legal educator and trial attorney. I have spent the last 20 years analyzing police encounters and constitutional case law. Today, we are not just going to talk about rights in the abstract. We are going to walk through the only 5 things you should ever say to a police officer. These aren't magic spells, but they are the specific verbal keys that unlock your constitutional protections. And we need to talk about why the rules have changed. In 2022, the Supreme Court decided a case called Vega versus Tekoh. This ruling effectively stripped you of the ability to sue a police officer for civil damages simply because they failed to read you your Miranda rights. The safety net you thought you had, that technicality that would get your case thrown out and win you a settlement, is largely gone. Furthermore, in 2025, the Supreme Court ruled in Barnes versus Felix. This unanimous decision changed how courts look at use of force, shifting the focus to the totality of circumstances leading up to an event. This means everything you say and do from the very first second of the encounter is now under a microscope like never before. To understand this, let's look at Elias. Elias is a 26-year-old graphic designer driving a borrowed car. He gets pulled over for a broken taillight he didn't know about. The officer approaches the window. Elias rolls it down halfway. The officer asks, "Do you know why I pulled you over?" Elias, trying to be polite, says, "I was probably going a little fast." Stop. Elias just confessed to a crime he wasn't even being stopped for. He has now given the officer reasonable suspicion to extend the stop. Reasonable suspicion is a specific legal standard. It is less than probable cause, which is needed for an arrest, but it is enough to detain you longer than a standard traffic ticket requires. By admitting to speeding, Elias opened the door. The officer now smells nervousness. He asks, "Where are you coming from, Elias?" Elias pauses. He doesn't want to say he was at a friend's house in a bad neighborhood because he thinks it will look suspicious, so he hesitates and stays silent. The officer asks, "Is there anything illegal in the car, Elias?" Elias stays silent. He thinks he is exercising his Fifth Amendment rights, but he's wrong. In the case Salinas versus Texas, the Supreme Court ruled that simply remaining silent before you're arrested does not invoke your Fifth Amendment right. If you just stand there mute, the prosecutor can later argue in court that your silence was evidence of your guilt. They can tell a jury, an innocent person would have said no, but Elias said nothing. So how does Elias survive this encounter legally intact? He needs to use the 5 phrases. Let's rewind the tape. The officer is at the window. He asks, "Do you know why I pulled you over?" Phrase number 1, "I prefer not to answer." It sounds rude to the average ear, but to a lawyer's ear, it is perfect. You are not lying, you are not confessing, you are politely declining to provide evidence against yourself. Most officers will push back. They are trained in psychological dominance. The officer might say, "Look, if you just work with me, we can get this over with." Or he might say, "You look nervous, Elias. What are you hiding?" This brings us to the most critical crossroads of the encounter. The officer wants to extend at the stop. He wants to look inside the car. He asks, "Do you mind if I take a look in the trunk?" Or, "I'm just going to check the back seat real quick, okay?" Phrase number 2, "I do not consent to any searches." Memorize this. I do not consent to any searches. Many people think that if they have nothing to hide, they should let the officer look. This is a fatal error. You do not know what is in your car. You do not know if the friend who borrowed it last week dropped a pill under the seat. You do not know if a previous owner left trace evidence in the trunk carpet. Furthermore, consenting to a search waives your Fourth Amendment protection against unreasonable search and seizure. If the officer finds something and you consented, your lawyer cannot argue that the search was illegal. You gave them the key. Now, here's the scary part. The officer might search you anyway. He might say, "I smell marijuana," or "I see something under the seat," claiming the plain view doctrine. Plain view allows officers to seize evidence they can see from a lawful vantage point without a warrant. If the officer says he's going to search, do not physically stop him. Never physically resist. But you must state clearly, "I do not consent to this search." This creates a verbal record that you did not agree to this, which allows your lawyer to challenge the search in court later. Let's go back to Elias. The officer is getting frustrated. He hasn't gotten a confession, he hasn't gotten consent to search, so he decides to keep him there. He leaves Elias sitting in the car for 20 minutes while he runs checks. This is a tactic to wear you down. Legally, a traffic stop can only last as long as reasonably necessary to issue the ticket. This was established in Rodriguez versus United States. Police can't extend a stop just to wait for a canine unit unless they have independent, reasonable suspicion. But Elias doesn't know when the clock runs out. He needs to find out. Phrase number 3. Am I free to go or am I being detained? This is the question that changes the nature of the encounter. It forces the officer to make a legal determination on the spot. If the officer says, "You are free to go," then leave. Don't stay and chat. Leave immediately and safely. If the officer says you are being detained, you have now established that you are in police custody for the purposes of the Fifth Amendment. The clock is ticking. The officer now needs to justify why he is holding you. If he cannot justify it later in court, everything he finds after that moment could be fruit of the poisonous tree, evidence that was thrown out because it was obtained illegally. Now, let's say the situation escalates. The officer orders you out of the car. Under the Supreme Court ruling Pennsylvania versus Mims, an officer has the right to order the driver out of the vehicle for officer safety. Do not argue this on the side of the road. Step out. But now, the officer starts asking probing questions. Where were you really tonight? Who are that guy you were texting? Why are your eyes red? This is the interrogation, and this is where Salinas versus Texas is crucial. You cannot just be quiet. You must speak to activate your shield. Phrase number 4, I am invoking my right to remain silent. You must say it out loud. I am invoking my right to remain silent. Once you say these words, the legal requirement for the officer to stop questioning you kicks in, though they often will not stop immediately. But you have now protected yourself from your silence being used as evidence of guilt. You have formally, successfully raised the Fifth Amendment shield. But the officer keeps pushing. You know, only guilty people ask for rights, alias. If you just tell me the truth, I can help you out. This is the false friend technique. Police officers are allowed to lie to you. They can tell you they have your fingerprints. They can tell you your friend already confessed. They can tell you the DA will go easy on you. None of it has to be true. So you need the nuclear option, the one phrase that stops the entire machine. Phrase number 5, I want my attorney. Not, I think I might need a lawyer, not, should I get a lawyer? Those are ambiguous statements. Courts have ruled that saying, maybe I should talk to a lawyer, is not a clear request. You must be direct. I want my attorney. Under Edwards versus Arizona, once a suspect in custody invokes their right to counsel, all interrogation must cease until an attorney is present. If they keep asking questions after you say this, the answers you give are generally inadmissible in court. So those are the 5 phrases. 1, I prefer not to answer. 2, I do not consent to any searches. 3, am I free to go or am I being detained? 4, I am invoking my right to remain silent. And 5, I want my attorney. But we need to address the new reality of 2025. I mentioned Barnes versus Felix earlier. This ruling emphasizes the totality of circumstances regarding use of force. This means your physical behavior is just as important as your words. If you are saying, I am invoking my right to remain silent, but you are reaching under your seat, or you are clenching your fists and stepping towards the officer, the courts may find that the officer's use of force was justified. You must de-escalate with your body while you escalate your rights with your words. Keep your hands on the steering wheel. If you're out of the car, keep your hands visible and away from your pockets. And there is one bonus phrase you should know for the modern era of policing. I am not resisting. If things go physical, if an officer grabs you, do not pull away. Pulling away is often charged as resisting arrest or assault on a police officer. Instead, go limp or comply with the physical movement, but say loudly and clearly for the body camera and bystanders, I am not resisting, I am complying. This creates audio evidence that contradicts an officer's report claiming you were fighting back. Now, let's talk about the exceptions, because the law is never black and white. There are times when these phrases won't stop the police. Exception 1, the warrant. If the police have a warrant signed by a judge, your consent doesn't matter. They are coming in. Do not physically stop them. Stand back, say, I do not consent, and let them execute the warrant.
Your lawyer will fight the validity of the warrant later. Exception 2, exigent circumstances. If the police hear someone screaming for help inside your house, or they are chasing a fleeing felon who runs into your yard, they do not need a warrant or your consent to enter. This is to protect life and safety. Exception 3, DUIs and implied consent. This is a huge trap. In most states, by obtaining a driver's license, you have impliedly consented to breathalyzer or chemical testing if you are arrested for DUI. If you refuse a breathalyzer after being arrested, you can automatically lose your license for a year or more, and your refusal can be used as evidence of guilt. However, the roadside blow into this tube test, the preliminary alcohol screening, is often voluntary. Know the difference between the roadside test and the post-arrest chemical test in your state. Let's return to Elias. Imagine he used the phrases, Officer, do you know why I pulled you over? Elias, I prefer not to answer. Officer, can I search your trunk? Elias, I do not consent to any searches. Officer, why are you being difficult? Just let me check. Elias, am I free to go or am I being detained? Officer, sit tight. The officer runs the license. It comes back clean. The officer knows he has no probable cause to search, and Elias hasn't given him anything to work with. He hands Elias a ticket for the broken taillight. Elias drives away safe. He didn't spend the night in jail. He didn't accidentally confess to a crime he didn't commit. He didn't have his car torn apart on the side of the highway. This is the power of legal literacy. But remember the Vega ruling. If the officer had arrested Elias and failed to read him his rights, Elias might get his statements thrown out of criminal court, but he likely couldn't sue the officer for money just for that mistake. This means the burden is on you to know your rights, because the system will not automatically compensate you for their violation. You are the first line of defense for your own civil liberties. Every time you speak to the police, you are building a record. That record will either save you or sink you. Don't rely on the police to tell you the rules. They are allowed to lie. Don't rely on Hollywood scripts. They are written for drama, not accuracy. Rely on the Constitution, but only if you know how to wield it. Memorize the 5 phrases. Teach them to your children. Write them on a card and keep it in your glove box if you have to. Because in the heat of the moment, with the lights flashing and the adrenaline pumping, you will revert to your lowest level of training. Make sure that training includes these words. I am not your lawyer, and this is not legal advice for your specific case. This is education for a free citizenry. Stay safe, stay educated, and know your rights, because rights that you do not know are rights that you do not have.